Pleading insane during a trial can be highly controversial, but what does it mean to be criminally insane? Could someone who is criminally insane get away with anything they want? At the most basic level, someone is considered criminally insane if they have a mental illness that makes it impossible for them to understand their actions when committing a crime. Another component of this is if the person's illness prevents them from knowing that their actions are wrong. This breaks the criminally insane plea down into two categories. The first is that the person's mental illness literally causes them to not know what they're doing. This could be due to a disease such as schizophrenia. The other category is people who knew what they were doing when they committed the crime but did not see it as morally wrong. This could happen with mental diseases that cause someone to have a complete lack of empathy for others. Either way, to be considered criminally insane, the defendant must plead guilty to committing the crime but prove that they were not culpable because of their mental illness. The evidence needed to prove someone is criminally insane varies by state, but in all cases, the defense must prove that they were either unaware of what they were doing or that they could not see it as morally wrong because of their mental state. It's also interesting to note that the definition of being legally insane is not determined by a psychologist but by the court. Psychologists and medical professionals do play a role in the analysis, but the designation of being criminally insane is given by the court itself. Someone can even be considered psychotic yet not meet the legal criteria for being criminally insane. We'll definitely see a case of this later. So, when is someone considered criminally insane? It all depends on the state they're being tried in. Some of the criteria may shock you. In most states, the courts adhere to what's called the Manhattan test. This test is used to assess the thought process and perceptions of the person at the time they committed the murder. So, when using the Manhattan test, the defendant does not need to be currently insane, they only needed to be cognitively impaired during the time of the crime. This means someone could seem completely normal in the courtroom, but still be declared criminally insane if their mental illness impaired their reasoning or drove their actions while committing the crime. In some states, such as Arizona, the courts revised the test to remove certain phrases. This was done to ensure that someone who knew what they were doing but did not believe it to be morally wrong because of their mental illness could also be considered criminally insane. Therefore, someone could be in complete control of their actions and know exactly what they were doing when they committed the crime, but if their morality was impaired by their mental illness, they could be considered criminally insane. This would lead to an acquittal of the charges if the Manhattan test was being employed. Another test used by about 20 states in the U.S. is the American Law Institute Model, or Bronner Rule. This test determines whether when the person committed the crime they lacked the capacity to appreciate the criminality of their actions. Of course, this also must be connected to some sort of mental disease or illness. The caveat is that this rule excludes mental illnesses that cause the defendant to commit the same crime over and over during the course of their life. Therefore, if someone is tried in a state using the Bronner Rule and their mental illness causes them to repeatedly commit the same crime, they cannot plead insanity. The final test is only used by one state, and that's the live free or die state of New Hampshire. The test they use is called the Durham test. This test only requires the defense to prove that the criminal act was a product of a mental disease or illness, which allows the definition of criminally insane to be much broader. The Durham test requires the defense to prove a lot less than other states. You may not be surprised that this makes pleading criminal insanity slightly easier in New Hampshire. Also, some defense attorneys in the state interpret the Durham test to include any mental illness, which makes what is considered criminally insane much more vague. Regardless of which state the defendant is in, the burden of proof is on the defendant, not the prosecution when seeking a plea of criminal insanity. The defendant must prove that they had a mental illness, which caused them to be unaware that they were committing a crime at the time. This is the exact opposite of a normal court case where the prosecution must prove beyond a reasonable doubt that the defendant is guilty. At this point, you may be wondering who has succeeded in pleading criminal insanity and what their crimes were. In today's court system, it is incredibly hard to win an insanity plea. In fact, it has one of the lowest success rates out of all criminal defenses, but that wasn't always the case. The first known assassination attempt on a United States president was by Richard Lawrence, who tried to kill Andrew Jackson in 1835. He fired 2 pistols at the back of the president, but they both misfired. Lawrence was tackled to the ground and arrested. In his trial, the jury learned that Lawrence was a house painter and may have been subjected to harmful chemicals during his work that made him mentally unstable. They found him criminally insane, and he was sent to several different mental institutions before he passed away in 1861. On October 14, 1912, John Schrank shot President Theodore Roosevelt while he was campaigning in Milwaukee, Wisconsin. The bullet struck Roosevelt in the chest, but he miraculously survived. When he was questioned by police, Schrank declared that President William McKinley had come to him in a dream and told him that he had been assassinated by Roosevelt, so Schrank was on a mission of revenge. Schrank also said, "I looked upon his plan to start a third party as a danger to the country. My knowledge of history, gained through much reading, convinced me that Colonel Roosevelt was engaged in a dangerous undertaking. I was convinced that if he was defeated at the fall election, he would again cry thief, and that his action would plunge the country into a bloody civil war. Schrank truly believed that the only thing he could do to save the country was to assassinate Roosevelt. The judge determined he was criminally insane, and Schrank spent the rest of his life in an asylum. You may be thinking that there is no way a third person attempting to assassinate a president would be declared criminally insane, but you'd be wrong. It seems like if you attempt to assassinate a president and fail, the way to go is pleading insanity as a defense. In 1981, John Hinckley Jr. tried to kill President Ronald Reagan. His insanity plea was bolstered by the fact that shortly before the assassination attempt, Hinckley wrote a letter that explained he was going to shoot the president to impress actress Jodie Foster. He clearly had a deeply unhealthy obsession with the actress. He was found criminally insane during his trial. However, this led to public outrage over the verdict and led to the Insanity Defense Reform Law of 1984. This law greatly modified the process for pleading insane and made it much more rigorous. Hinckley was sent to an asylum but allowed to make a periodic visit to his mother. With the reforms put in place after Hinckley's case, it became much more difficult for someone to win an insanity plea. For example, 1991, Jeffrey Dahmer was convicted of murdering, mutilating, and cannibalizing 15 young men. At his trial, he admitted to the killings and put in for an insanity plea. The court rejected the plea, and his case was sent to trial where he was convicted as a legally sane individual. He was sentenced to 15 consecutive life sentences in prison with no chance of parole. The treatment of Dahmer's case prompted many to believe the end of the insanity defense had finally come. The result of the case may have been in direct response to the acquittal of Hinckley during his trial. If the defense could not prove that Jeffrey Dahmer was legally insane, it seemed that no one would ever be able to plead insanity and win ever again. However, this was not the case. In 1994, Lorena Bobbitt was declared criminally insane for her trial for cutting off her husband's penis and throwing it out the car window while driving down a Virginia highway. Bobbitt said the reason she did this was because of years of emotional, physical, and sexual abuse by her husband. After being found criminally insane, she was sent to a mental hospital for 5 months before the judge ordered her released. We know that in order to be considered criminally insane, the defense must prove that the mental illness made them unable to comprehend what they were doing during the time of the crime. From the stories of people who were found criminally insane, most were sent to mental hospitals. But is this always the case? The law says that if someone is found criminally insane, they should be immediately committed to a suitable facility. That is, unless the court finds that releasing the person back into society would pose no substantial risk of bodily harm to themselves or others. They must also pose no risk of damaging another's property as a result of their mental illness. If this is the case, the person will be set free. If someone's found criminally insane and they do pose a risk to others, they are handed over to the Attorney General, who must find them a suitable institution to reside in. After the Attorney General does their job, the person is surrendered to the state, who is in charge of custody, care, and treatment of the individual. Once the state deems that a person can safely be released back to society, they will be. This does not always happen, and some people who are found criminally insane will spend the rest of their lives in a mental health institution. Winning a plea of insanity is incredibly difficult because of the strict rules and laws around what constitutes being legally insane. The defendant must prove without a doubt that during the time they committed their crime, they had a mental illness that impaired their judgment or made them unaware that they were doing anything wrong. Now watch journalist goes undercover at insane asylum, becomes prisoner, or check out average day in an insane asylum.